Welcome to this episode of Law and Society in Taiwan, and today we will talk about the Judicial Yuan. The judiciary in Taiwan is called the Judicial Yuan. The Judicial Yuan, according to the Constitution of the Republic of China, is the highest judicial organ, and it is responsible for civil, criminal, and administrative cases. Also disciplinary measures against public functionaries according to Article 77 of the Constitution. Most important of all, according to Article 78 of the Constitution, the Judicial Yuan has the power to interpret the Constitution and to unify the interpretation of the laws and legal orders in Taiwan. So these two are the core functions of the Judicial Yuan: to interpret the Constitution and also to ensure a uniform interpretation of all statutes and regulations. However, as we know, the Constitution has been amended, and therefore later the Constitutional Court also received the power to dissolve unconstitutional political parties that have goals that endanger the existence of the Republic of China or the nation's free and democratic constitutional order. Moreover, the Constitutional Court later on, since 2005, also received the power to impeach the president. So, as I mentioned in the introduction, the Judicial Yuan has power over civil and criminal cases. But we also know that the Judicial Yuan is the highest judicial instance. So when we want to start a lawsuit, we don't directly go to the Judicial Yuan, right? So the question is, where do we go in the first place? And here you can see, in the first place, we go to the ordinary courts. The ordinary courts are organized in 3 levels according to the Court Organization Act. At the first level, we have the district courts, which determine the facts. Then they make a judgment, and if a party is not satisfied, then the party can appeal to the High Court. So the High Court hears the appeals. And finally, we have the Supreme Court, which then will review the law, but only questions of law and no longer the facts. The jurisdiction of the ordinary courts, so they are responsible for the civil and also the criminal matters, but also other litigation issues that are provided by law, and also non-litigation matters such as notarization, civil compulsory enforcement, bankruptcy or consumer insolvency. So we see that the ordinary courts have a pretty broad range of matters that they can decide. I would just like to remark that in addition to the ordinary courts, we also have some specialized courts for intellectual property and commercial cases, for juvenile and family proceedings, and for disciplinary cases against judges, prosecutors, and public servants. Okay, so these are the ordinary courts. Let's move on to the administrative courts. So in administrative matters, we also have special administrative courts in Taiwan. And according to the Administrative Court Organization Act, these courts are generally divided into two levels. So in the first instance, in ordinary administrative proceedings, we go to the so-called high administrative courts, and we have three located in Taipei, Taichung, and Kaohsiung. And then we can appeal to the Supreme Administrative Court. However, even though the Administrative Court Organization Act here speaks of two levels, since 2012, the district courts also have established a special division for administrative litigation in smaller cases, for smaller cases such as summary proceedings where the disputed amount is less than 400,000 Taiwan dollars. So here we have also the administrative courts. Now, when we have already reached the Supreme Ordinary Court or the Supreme Administrative Court, is there still a way to reach another instance? And this is the special part now, that when we already have a final court decision, but there is the question whether this judgment might contravene the Constitution. Then there is the special possibility that we can go to the Constitutional Court. And this is provided for in the Constitutional Court Procedure Act, Article 56. So Article 56 says, after exhaustion of all ordinary judicial remedies, any person who believes that a final court decision or a legal provision applied in such a court decision contravenes the Constitution may lodge a petition with the Constitutional Court within 6 months. Now, when the Constitutional Court makes a decision, then this decision is really no longer appealable according to Article 39. And according to Article 38, the judgment shall be binding on all authorities and people, and every authority has the obligation to implement the judgment. So if you take a look at this kind of judicial system in Taiwan, it actually reminds us of the judicial systems in European countries. For example, Germany, Austria, Italy, and Spain, which also have special courts for constitutional reviews. So the Taiwanese system in this regard follows the European continental system. Now let's talk about the grand justices in more detail. So within the Judicial Yuan, we have the Constitutional Court, and this Constitutional Court is composed of 15 Grand Justices, including a President and a Vice President, according to Article 5 of the additional articles. And when the Constitutional Court sits in a full court, so all the members, then it's called en banc, or it can also sit in chambers composed of 3 justices. And the president of the Judicial Yuan is also called the Chief Justice. So obviously, this is a very important function that the Grand Justices here play, right? They have big power. They are the ones who interpret the Constitution, which is the supreme law of the nation. So how do you become a Grand Justice? They are nominated by the President and appointed with the consent of the Legislative Yuan. So it's not the President alone, but here we need the approval also of the Legislative Yuan. And these Grand Justices, often they can be experienced judges, but also prosecutors, lawyers, professors, or legal scholars. But in any event, the experience here obviously also is very important. So they are very distinguished persons. According to Article 81 of the Constitution, the judges shall hold their office for life and not be removed unless they commit a criminal offense or a disciplinary measure. However, this provision that applies to judges does not apply to the Grand Justices. So the Grand Justices, they serve a term of 8 years, and they may not serve a consecutive term. And the Judicial Yuan President and the Vice President, they do not enjoy this guarantee of the 8 years. So in any event, the terms of the Grand Justices here are limited. Very important also here is Article 80 of the Constitution, which provides that judges shall be above partisanship and hold the trials independently from any interference. So this enshrines the principle of judicial independence. Yeah, this is very, very important that the judges are independent, so they don't have to obey their superior, as would be the case in the administrative. Here, the judges make the decisions according to the law, according to the conscience, independently. And Article 82 of the Constitution refers to the organization and the courts of various grades, that these are prescribed by law. And so we have some special laws, such as the Court Organization Act or the Judicial Yuan Organization Act, and also the Constitutional Court Procedure Act. So I just mentioned the Constitutional Court Procedure Act. This is a very important law. It's also abbreviated CCPA, and it was amended recently in 2019 and effective this year, 2022. So let's compare what is new now, what are the novel things about the Constitutional Court Procedure Act. So according to the Constitutional Court Procedure Act, the name now is the name of the court is called Constitutional Court. So previously we often you also used the term Council of Grand Justices, which were composed of the 15 justices, but now the term is very clearly defined as constitutional court. And we now have also a new system of chambers. So to make it more efficient, the decisions do not always have to be taken by all the 15 Grand Justices, but it's possible to have the chambers composed of 3 justices. Also, the result of this decision now is called the judgment of the Taiwan Constitutional Court. Previously, we used to say the Judicial Yuan interpretation, but now the name is very clearly called the judgment of the Taiwan Constitutional Court. Also, the scope of judicial review has been enhanced. Previously, the Council of Grand Justices only had the power of abstract review, which means to review a statute or a regulation that was applied in a court decision, and then to determine whether this statute or regulation conforms with the Constitution. However, according to the latest reforms, the jurisdiction of the Constitutional Court has now been expanded also to include a concrete review, the concrete review not only of a general law, but also of the final court decision itself, which is called a constitutional complaint. So this means the Taiwan Constitutional Court can overturn an unconstitutional court decision and remand it back to the original court for retrial. So this is very important. The Constitutional Court also now has the power of concrete review of a final court decision. Also, the procedure has become more transparent thanks to the possibility for amici curiae to submit their expert opinions and information. So this term amici curiae is a Latin term, and it literally means friends of the court. So amici means friends, and curiae means court, friends of the court. So these are persons or authorities or associations having an interest in a pending case. And they now expressly have the possibility to submit their opinion and also to provide information to the Constitutional Court. So these are some of the most important reforms that have come into effect this year. So now that we know how the Constitutional Court is organized and what powers they have, let's talk about some cases, some of the milestone cases. One of them is a Judicial Yuan interpretation number 261 from 1990. And what happened in this case, so what happened here was that the re-election of national legislative bodies was mandated. So the Constitutional Court mandated that the national legislative bodies must be re-elected because since 1949, so that was when the government moved from mainland China to Taiwan. Thereafter, there were no complete re-elections. So that's why the court in 1990 ordered, now it's time, please re-elect. And this decision is very important because it opened the door to Taiwan's full democratization in the 1990s. Another case from the year 2000 is Judicial UN Interpretation number 499. And this interpretation is special because it declared unconstitutional the additional articles of the Constitution enacted in September 1999. So what was the problem with those constitutional amendments from 1999? There were manifest procedural flaws because the general public had not been informed how the delegates of the National Assembly exercise their amending powers. So here I have to explain the National Assembly does not exist anymore today, but previously, according to the Constitution, the National Assembly would exercise the powers of on behalf of all the people of the Republic of China. So at that time, it was a kind of indirect democracy. But the problem was that how these delegates of the National Assembly exercised the power was not transparent, yeah, and so this contravened the principle of openness and transparency. And therefore, this Judicial UN Interpretation number 499 from the year 2000 is one of the few decisions in the world that have declared constitutional amendments unconstitutional. And now let's talk about a more recent decision, that is Judicial UN Interpretation number 748, which was decided on 24th May 2017. This case is about same-sex marriage in Taiwan, and it declared unconstitutional the part of the civil code that deals with marriage. Because according to the civil code, the same-sex marriage was not recognized. And this now has been declared unconstitutional, and this decision of the Judicial UN was really implemented by the Legislative Yuan in 2019, so 2 years later. And this result is that Taiwan now is the first place in Asia and the 27th nation in the world to legalize same-sex marriage. So this is a very controversial issue, and we see that the Judicial UN, the Constitutional Court here, played a crucial role in legalizing same-sex marriage. So let's talk about this case in more detail. So in this case, we had two petitioners. Petitioner number one was a person called Mr. Qi, and he has for more than 30 years been fighting for the right to same-sex marriage. He has requested the legislative, the executive, and the judiciary to allow same-sex marriage. In 1986, he petitioned to the Legislative Yuan. In 1994, he petitioned to the Ministry of Justice and the Ministry of Interior. And in 1998, and also in the year 2000, he went to the Taipei District Court, but he always failed. And so finally, he appealed and appealed. He continued to file the remedies. And that was why in 2001, this case came before the Taiwan Constitutional Court. However, it was dismissed at that time in 2001. But Mr. Qi did not give up, and he tried again in 2013, went to the household registration office in Taipei City. So if you want to marry, you have to go to the household registration office to register your marriage. But again, this registration failed. It was his marriage was not registered, and so he again appealed to the Supreme Administrative Court in 2014, and again this case was dismissed. So Mr. Chi then in 2015 again petitioned the Taiwan Constitutional Court for a constitutional interpretation. So this is now the crucial point, 2015, where the case again comes to the Taiwan Constitutional Court for a second time, and this time he claimed that Articles 972, 973, 980, and 982 of the Civil Code, as applied in the judgment of the Supreme Administrative Court dating from 2014, violates Article 7, 22, and 23 of the Constitution, and also Article 10 of the additional articles. So this case is now pending before the Taiwan Constitutional Court since 2015. The other petitioner in this case is the Taipei city government. Now you might wonder, why would the city government care about same-sex marriage? Well, as I said, the city government here is the competent authority according to the Household Registration Act. So if you want to marry, you have to go to the city government to register your marriage. And the Taipei city government is supervised by the Ministry of Interior of the Executive Yuan. And what happened now before the Taipei city government was that there were some same-sex couples that wanted to get married, but they could not, and therefore they filed administrative lawsuits. So this was the reason why the Taipei city government then decided to file a petition to the Taiwan Constitutional Court in November 2015 and to ask whether the Civil Code and also a letter of the Minister of Interior violates the Constitution. So now we understand why this case has come before the Taiwan Constitutional Courts. So there were the two petitioners, and both petitions concerned the constitutionality of the Civil Code, and the Constitutional Court decided to consolidate these two cases. Yes, and on this slide, we can see the oral hearing before the Taiwan Constitutional Court held on 24th March 2017. So we don't have the time to watch this video together now, but I recommend that you take a look at these links that I provide here, and then it will be very interesting, right, for you to see how is an oral hearing being conducted. So you see the real court, you see the justices, and you see all the parties, how they argue, and then how they argue the arguments. So now let's talk about the legal issue. So we now understand the factual background, but of course, from a legal perspective, the main issue here is the following question. Namely, does the Civil Code, which does not allow two persons of the same sex to create a permanent union of intimate and exclusive nature for purpose of living a common life. Yeah, so this is the definition. This is what makes the nature of marriage. It's a permanent union. Does this prohibition, yeah, of the civil code violate the freedom of marriage under Article 22 of the Constitution and the right to equality under Article 7 of the Constitution? And the holding or the answer to this issue is the civil code does not allow persons of the same sex to create a permanent union of intimate and exclusive nature for the purpose of living a common life. And this violates the freedom of marriage under Article 22 of the Constitution, and it violates the right to equality under Article 7 of the Constitution. And therefore, the authorities shall amend or enact legislation to implement the equal protection of freedom of marriage for persons of the same sex within 2 years. So the decision of the Constitutional Court here is clear. Yeah, it's a violation of the Constitution, but with regard to the implementation, the Constitutional Court leaves room for discretion. Yeah, so they give also a longer period of time, namely 2 years. They know this is a complicated matter, and to either change the civil code or to enact new legislation, and so they have provided a period of 2 years to the in order to implement this decision. Now that we understand the legal issue and also the holding of the court, let's take a look at the black letter law. So here we see the legal provisions. Article 7 of the Constitution says, all citizens of the Republic of China, irrespective of sex, religion, race, class, or party affiliation, shall be equal before the law. So here we have the right to equality, and in particular, it prohibits discrimination because of sexual orientation. According to Article 10 of the additional articles, the state shall protect the dignity of women and eliminate sexual discrimination and further substantive gender equality. So this is also a very interesting provision in the additional articles of the Constitution that provides a mandate to eliminate sexual discrimination. The next relevant provision is Article 22 of the Constitution, which says all other freedoms and rights of the people that are not detrimental to social order or public welfare shall be guaranteed under the Constitution. So why is this provision important? Because the Constitution lists the rights and freedoms, but it does not expressly talk about the freedom of marriage. However, thanks to this Article 22 of the Constitution, it says, even if the rights are not expressly enumerated or listed or mentioned in the Constitution, they can still be protected by the Constitution, yeah, as long as it's not detrimental to social order or public welfare. And based on this Article 22, the freedom of marriage is also protected by the Constitution, and the freedom of marriage includes not only the freedom to decide whether to marry, but also the question who to marry, whom to marry. Yeah, and because this freedom of marriage also is closely related to the freedom of personality and human dignity, and therefore is also considered a fundamental right. A union by persons of the same sex will not affect the union of persons of the opposite sex, nor alter the social order established upon opposite sex marriage. Freedom of marriage for persons of the same sex, once legally recognized, will constitute a stable society together with the opposite sex marriage. So these were the arguments of the Constitutional Court, right? So they said, well, if we, even though we have the traditional marriage between the opposite sexes, but even if we now legalize the same-sex marriage, this will not be detrimental to the social order or public welfare. Yeah, so just because we recognize the same-sex marriage does not influence the opposite sex marriage. So this was the reasoning of the court, yeah, that both types of unions shall be protected by the freedom of marriage according to Article 22 of the Constitution. Another provision that has to be taken into account in this context is Article 23 of the Constitution, which enshrines the principle of proportionality. So proportionality means that enumerated freedoms and rights shall not be restricted by law except necessary to prevent infringement upon freedoms of other persons, to avert imminent crisis, or to maintain social order or advance public welfare. So we know that the freedoms and the rights, even though they are protected by the Constitution, does not guarantee a 100% protection, because we also have to respect other people's freedoms and rights. So therefore, it can be possible to restrict the constitutional freedoms and rights, but only if this is really necessary. Yeah, and what does necessary mean? Well, here we have first to ask, is there a public interest why we need to restrict? And then we have to ask, well, what is the method or the tool in restricting? And then we have to balance these two, the objective, the public interest, and the method, and then ask, is the method really necessary in order to achieve this public interest or objective? Yeah, so this is the principle of proportionality. In other words, a different treatment based on sexual orientation must be aimed at furthering an important public interest. So this is now the reasoning of the court. Yeah, they look at the aim, the objective, and says it has to be a public interest. Yeah, and by means that are substantially related to that interest in order to satisfy the right to equality under Article 7 of the Constitution. So here, in this reasoning of the Constitutional Court, you see how the court asks for the aim, the objective. Yeah, the purpose must be a public interest, and the means, the method or the tool, yeah, that is applied here by the government. According to the legal reasoning of the Constitutional Court, the court here also argues that reproduction is not an essential element to marriage. So disallowing marriage of persons of the same sex because of their inability to reproduce has no rational basis. So this is an interesting argument that was brought before the court. Those parties that were against the same-sex marriage, they argued, that only men and women, they can have children, and that is why only men and women should be allowed to marry. However, the advocates of same-sex marriage, they argued, look, not all couples, not all men and women who are married have children, and therefore having children, the reproduction is not an essential element of marriage, and so this argument was also adopted or recognized by the Constitutional Court, that reproduction is not an essential element to marriage. Another argument was that the basic ethical orders remain unaffected. So what does this refer to, ethical order? So marriage, for example, requires a minimum age, or you should be loyal to your partner, so this is called monogamy, to your partner, and or marriage shall be prohibited between close relatives, and there is an obligation to maintain each other. But all these ethical orders remain unaffected, right? So they still apply. These provisions still continue to apply even if we recognize same-sex marriage. So the one does not affect the other. Not allowing persons of the same sex to marry for the sake of safeguarding basic ethical orders, therefore has no rational basis, and therefore the different treatment between same-sex couples and opposite-sex couples is incompatible with the right to equality according to Article 7 of the Constitution. So this was the argument of the Constitutional Court. So now it's high time for us to take a look at the Civil Code itself. So the Civil Code regulates families, and in particular the marriage in Chapter 2 of Part 4. And Article 972 of the Civil Code says that a betrothal agreement shall be made by the male and the female parties in their own concord. So this is the classical agreement to get married. So this is not marriage itself, but the promise to marry. And according to this Article 972, this kind of agreement to marry can only be made by a male and a female person. So this is based on this provision, we can derive that a marriage is only possible between a man and a woman. If we continue to read Article 973, it says a male or female who has not reached the 17th year of age may not make an agreement to marry. And Article 980 says a male or female who has not reached the 18th year of age may not conclude a marriage. And Article 982 says a marriage shall be effected in writing. It requires the signatures of at least 2 witnesses and shall be registered at the Household Administration Bureau. So the interesting thing here to note is that Articles 980 to 985 stipulates the requirements for concluding marriage, and these provisions by themselves do not stipulate that marriage can only be concluded between a male and the female. But as I mentioned, because of Article 972, that a betrothal agreement to marry in the future can only concluded between a man and a woman, that's the reason why we know that in the end, ultimately, marriage is only possible between a man and a woman according to the civil code. And also the appellation for the parties of a marriage, we call them husband and wife. Based on this kind of appellation and also the rights and obligations provided in the marriage chapter, it's obvious that marriage shall mean a union between a man and a woman or two persons of the opposite sex. So you now understand the civil code, the civil code, why the civil code only allows a man and a woman to get married. Yes, so there was also an issue with the Ministry of Justice and the Ministry of Interior, but we will skip this part because this has not been, this argument then was not successful, so we will skip this part. So now that we know the outcome of the Taiwan Constitutional Court, which ruled that the marriage only between a man and a woman is unconstitutional. Nevertheless, what is interesting is that a national referendum was held on 24th November 2018. So we know the judgment was decided in May 2017, but notwithstanding this judgment, a national referendum on this question was held 1 year later in November 2018. And one of the questions that was put to the national referendum was, do you agree that civil code regulations should restrict marriage to being between a man and a woman? So do you agree that the current status of the civil code should be maintained? And this question passed. So the majority of citizens in Taiwan, they want the current civil code to stay just the way it is, to allow marriage only between a man and a woman. So this is very interesting to see, right? Because it actually is opposed to the outcome of the Constitutional Court. The other question that was put to the national referendum was whether to protect the rights of the two same-sex persons to create a permanent union in a form other than marriage of a civil code. So in order to protect the rights of same-sex persons, should we provide another form apart from the civil code? And this petition also passed, which showed that a majority of the citizens in Taiwan, they think, yes, it's, we don't want to change the civil code, but it's okay to make another law in order to protect the rights of same-sex couples. And then another question that was asked at the national referendum was, should civil code marriage regulations be used to guarantee the rights of same-sex couples to get married? And this petition was rejected. So again, this question is very similar to the first question that was asked. Yeah? So this means that the majority of the people don't want to change the present civil code. Yeah? So the civil code as it is now protects only marriage between men and women, and this should not be used also to protect the rights of same-sex couples. So the majority of the citizens in Taiwan, they prefer to make an extra law. So now that we know the judicial yuan interpretation, which was published in May 2017, wanted to legalize the same-sex marriage, but at the same time it left discretion to the authorities to determine the formality, how to implement this decision. Yeah, either by amending the civil code, yeah, the marriage chapter, or to enact a special law. And we now know what is the way forward, namely the latter alternative, namely to enact a special law, because the majority of the people in Taiwan, based on the 2018 referendum results, advocate that the current civil code should remain unchanged, and we prefer to enact a special law. So enacting a special law actually has been discussed in the Legislative Yuan since 2006, and then again since 2016. And now, based on this referendum and also the Constitutional Court decision, the Executive Yuan in February 2019 passed a bill, and then they forwarded this bill to the Legislative Yuan. And the Legislative Yuan passed this bill, so it became a law, and it's called Act for the Implementation of the Judicial Yuan Interpretation number 748, and it was passed on May 17th, announced on May 22nd, and became effective May 24th, 2019. So this is now the important milestone in Taiwan, that since May 2019 we have a special law that recognizes same-sex marriage. And according to this law, Article 2, it says, two persons of the same sex may form a permanent union. And in Chinese, the original words is called 永久结合关系. Yeah, so it's a permanent union of intimate and exclusive nature for the purpose of living a common life. This is interesting to note, right? They don't expressly use the term marriage, but they call it a union. Yeah, 永久结合关系. According to Article 4 of this law, the union shall be effected in writing. It requires the signatures of two witnesses, and it shall be effected by a marriage registration at the Household Administration Bureau. Yeah? So if you want this kind of permanent union, you have to go to the Household Administration Bureau, and you basically have to file a marriage registration. So in Chinese, the wording that is used is 结婚登记. Yeah, you have to register the marriage. So this is now the place, yeah, where the law really uses the term marriage. According to Article 24 of this milestone law, the civil code concerning couple spouses and the conclusion of marriage, and other laws concerning couples, spouses, and conclusion of marriage shall apply mutatis mutandis to a union as stated in Article 2, unless there are certain exceptions. Yeah, so it says, okay, we don't change the civil code itself, but the provisions of the civil code that apply to marriage shall be applied in the same way to this kind of union between the same-sex couples. So I think this case is very important. It's very interesting. Yeah, as I said, it's a milestone judgment, and it made Taiwan the first place in Taiwan in the whole Asia to recognize same-sex marriage. So now let's talk about some other judicial reforms. The latest reform is to promote civil participation in trials, and the name of the law is called Citizen Judges Act, or in Chinese 国民法官法. This law was passed by the Legislative Yuan on the 22nd of July 2020. It was promulgated on the 12th of August 2020 and will become effective on the 1st of January 2023. So right now, this Citizen Judges Act is not effective yet, but it will soon enter into effect. So this is now an important reform to promote civil participation in trials. We know that traditionally that the trials are conducted by the professional judges. But what was the result? The result was that often the outcome of this kind of civil trial, of this kind of judicial trial, would be a surprise for the people, yeah, because the judges, they are legal experts, they make their decisions according to the law, but the people who don't have the legal knowledge, yeah, they would maybe often not agree with this kind of judgment. So in order to close this gap between the judicial proceedings and the feelings of the citizens, yeah, now we have this new law to promote the participation of citizens in trials. So let's take a look at this new law. Yes, so according to Article 1, both citizens and judges shall participate in a criminal trial. So this law only applies to criminal trials. And the purpose is to enhance the transparency of the judiciary, also of the public opinion towards the law, and to enhance the public confidence in the judiciary. According to Article 3, we have 3 judges and 6 citizen judges who will participate in a case, in a trial. As far as the applicable cases are concerned, Article 5 says that this kind of citizen participation only applies to serious or major cases or felony offenses, yeah, where the minimum punishment or imprisonment is 10 years or more, or where a crime, an intentional crime has been committed that resulted in death. So we see that the participation of citizens in criminal trials is only reserved for major cases, for very serious cases. However, Article 6, on the other hand, excludes certain cases. Namely, it says the participation of citizen judges is not appropriate, for example, when a case is very complicated or it requires highly specialized expert knowledge, and it's difficult to conclude within a short period of time. So much to the applicable cases. The next question is, who can become a citizen judge? According to Article 12, you have to be a national of the Republic of China. You have to be at least 23 years old and reside within the jurisdiction of the district court where the criminal trial is being held. And you must have resided there for at least 4 months. Then you are eligible as a citizen judge. On the other hand, who is disqualified? The grounds of ineligibility are provided in Articles 13, 14, and 15, where it says, for example, that the prosecutor who has initiated the public prosecution, or judges and law professors, or any person who is not impartial, for example, relatives of the accused or victim, they are not qualified to serve as a citizen judge. So obviously the reason here is we want to have objective citizens without a legal background here to participate in the trials. Yeah, so they must not be legal experts, and they must not have an interest in the case. The next question is how to select the qualified citizen judges. And Article 17 of the law here tells us that the citizen judges are selected randomly from eligible individuals who live within the jurisdiction of the district court. If a citizen lacks the qualification or the eligibility, then the court shall rule not to select the person either ex officio or upon petition of the parties or the defense attorneys. And according to Article 28, a prosecutor, the accused, or the defense attorney may, without giving a reason, request the court not to select a specific citizen. Yeah, so here the selection procedure is first we have those persons that are disqualified, and from those that are qualified, it's still possible to reject certain persons. And interesting here that the prosecutor and the accused and the defense attorney, they don't even have to give a special reason if they want to refuse if they want to refuse certain citizens from serving as citizen judges. Now, if you look at the trial procedure, Article 82 says that there shall be a full panel of judges and citizen judges. And as I mentioned, we normally have 3 professional judges and 6 citizen judges. And together, they shall find the facts and apply the law and the sentencing. According to Article 85, the final deliberations shall be strictly confident, and according to Article 83, a verdict of guilty must be approved by 2/3 of the members and must include at least 1 citizen judge and 1 judge. So this is interesting to note here that the citizen judges have the equal rights just like the professional judges. Yeah? So the citizens, they participate not only in the findings of the facts, but also in the application of the law and the sentencing. And this is a little bit different from the United States, where the so-called jury are only responsible for the fact finding. And under Chapter 5, talking about penalties, Article 94 says, a citizen judge who demands or takes improper benefits for refraining from exercising his duties or for exercising such duties in a certain manner can be punished with imprisonment between 3 to 10 years, and in addition, a maximum fine of 2 million Taiwan dollars may be imposed. So of course, we want to make sure that the citizen judges are really impartial, and they have to be independent, under the threat of punishment. This kind of system where citizens participate in criminal trials shall be assessed starting 2023 after a period of 6 years. So we know that this system of civil participation is completely new in Taiwan, and therefore the law itself says that after 6 years it shall be reassessed. Coming to a conclusion now, the task of the judiciary is to interpret the law objectively, free from any interference. But sometimes there may be gaps between the laws, for example, including the judicial interpretations on the one hand, and people in society. As we see, sometimes the public referendum may be opposed to the outcomes of a judgment. The case concerning same-sex marriages in Taiwan demonstrates how controversial issues can be resolved in a democratic society. Above all, it highlights the fact that laws and society may be difficult to change, but they do change in the course of time.